This is the Data Privacy Detective, and today we're going to talk about the America Privacy Rights Act and whether it's ever going to get adopted as a United States law or not. You know, you'd think that if the Democratic chair of the Senate committee in charge of this stuff and the House Republican chair of the House committee that deals with this kind of question get together and write up a very detailed act that gets changed and reviewed by the Congressional Research Service and gets other sponsors, and they agree on this, the thing would sail through. But we live in America in a very divisive election year, 2024. And we're going to talk about where it's headed, and not so much to get into the weeds here, but to say, what's the debate about these days about privacy and business and commerce and artificial intelligence and everything else? And with us, we have my good friend and colleague, at least once a month on this show, Yugo Nagashima. Now, Yugo, thank you for joining us today.
Happy to be here. Thank you so much for inviting me.
Well, happy or not, this is quite a thing we're going to be talking about. And Yugo, you're a privacy and intellectual property attorney with the firm of Frost Brown Todd, a great coast-to-coast law firm. And of course, neither you nor I take any position about this. Let's talk briefly about what the APRA, there's an acronym, American Privacy Rights Act. There was, it's out there. It's supported by the two key committee chairs, one Republican, one a Democrat, covering a whole host of things, aiming to get a national approach to how we deal with data privacy. Wouldn't that be a fine idea? And they've agreed, and they put it out there, and there have been changes, and off it goes. And now you've got some update for us. Well, you'd think this would just sail through. What's happened?
Yes, the latest update, unfortunately, isn't that great of news. The American Privacy Rights Act, and we'll call it APRA, spearheaded by the House Energy and Commerce Committee leaders. And as you mentioned, Republican on one side, Cathy, McMorris, Rodgers, Washington State, and Democrat Maria Cantwell, Washington State. I believe
I
mentioned
both from big tech, a big tech state. That's it's a big tech state, so you'd think they've thought about individual rights and big tech and so on, but go ahead.
Right. So those two are working together, but, and here's the big but, has received opposition from top GOP leaders. And just last week, right, the Energy and Commerce Committees had a markup schedule. So markup is, making edits and bringing the act into a better place.
And last week was the end of June 2024 for listeners.
That's right.
Go ahead.
Right. The opposition raised by Speaker of the House, Mike Johnson, and Steve Scully said,
those are powerful people. They said what?
They basically said APRA it has issues, right? There are issues that particularly deals with the private right of action, although there are other issues like preemption and others, which we will talk about later. But the biggest issue that the GOP leaders had was over this private right of action, which I believe one of our old podcasts has already covered.
Well, private right of action, that's where an individual can sue or class actions can be filed on behalf of individuals versus the Attorney General of a state or the United States or the Federal Trade Commission acting as government supervisors, right?
That's right.
Now, well, what's the problem with that? I mean, this is about creating rights for individuals. Why couldn't they sue? What's the problem?
Right. It sounds too good to be true, but according to the members of the GOP, it might create excessive lawsuits because now an individual has a right to sue. So let me get into a little more detail. So the GOP believes that allowing a private right of action would unleash a lot of lawsuits on small businesses. Similar to patent trolls, if anyone knows what that is, suing every small business back in the early 2000s and the mid 2000s and the early 2010s as well.
Well, what do you mean by patent trolls? Talk to us about that.
Patent trolls are They're also known as patent assertion entities. There are companies that bring lawsuits against others by filing a complaint at the court and trying to basically negotiate a settlement. And again, some, entities asserting a patent, they have the right to do it, and they may have the merits. But because of our system, right? Because of our litigation system, because the cost of hiring lawyers and litigating a case is very stressful and expensive, there was a time in the 2000 and early 2010s where many companies and individuals were sued and were forced to settle without the parties really discussing the actual merits of the case. Because to get to that point, you had to spend thousands, if not millions, to do so. What the GOP is arguing is that it would be individuals working with trial lawyers. So, someone bringing a private right of action would work with lawyers to bring such claims under the APRA and start a whole bunch of lawsuits against small and mid-sized businesses who would just have to say, you know what, I can't hire a lawyer. I can't argue this at the very end. Let's just settle. And that's the concern for the Republicans.
All right. Well, let me ask you a question about that, though. The small business is a defined term in the draft of the APRA, and it's businesses that have $40 million or less in annual revenue, or collect, process, retain, or transfer covered data of 200,000 or fewer individuals. Now that would exclude from this act as drafted more than 90% of the businesses in America. So you're really talking, aren't we, about the problem of class action lawsuits being filed against very substantial companies.
Again, that may be true. The concern here, I think, and I'm not trying to defend the GOP position, but the position is that we don't want excessive lawsuits, and they may consider any business or a $40 million business, because they're not in the billions, like the bigger ones. They're still a growing business, budgeting business. They don't want them to be sued, and I think that is one of the concerns.
A number of the state codes that have been adopted, we have over a third of the states now have codes, and many of them do not allow a private right of action under state law. Is that right?
That's right. I believe Vermont was an exception, but I believe the governor vetoed it. And so currently there is no private right of action, except for California has a small exception for the data breach aspect of
data breach.
APRA.
But I'm just asking, let's just guess that to bridge this problem, the private right of action gets deleted. Are there other objections that on the GOP side they're making that are major?
So I think that was the biggest in the latest iterations of edits.
Preemption, of course, and preemption just simply means that the federal law would supplant the various state codes that, for the reason of having a national approach to how you handle data privacy. That's good for interstate commerce.
Right.
So maybe that's another. And then there are all sorts of other things well, how about the other side? How about the Democratic side, the civil rights side, civil liberties side? How do they feel about the current draft?
So they're not happy either. And I think that's an important point that we have to make. The civil liberties side, like the ACLU and AACP and the Human Rights Campaign, have urged the committee to postpone the markup as well. So on what reason, right? It goes to the algorithmic audit provisions, which have been severely, or not severely, but relatively been defanged. Originally, the language for the algorithmic audit, and that goes like AI, AI review, impact assessments. Those originally had that if it would have a critical risk or substantial risk on the consumers, but now the language has been changed to a consequential decision, which is a little bit of consequential risk to it, of harm to a consumer, and now it's been changed to consequential decision, which blurs the line a little bit. It may sound similar, but these civil liberties organizations are arguing that it's become weaker and that the original edit should return. So they're also asking the committee to basically postpone the markup as well.
Well, what this is dealing with is bringing AI, artificial intelligence, and algorithms, that's what you're talking about, that drive AI into the data privacy orbit. I mean, when GDPR was adopted in Europe, some people consider it the gold standard on the pro-privacy side. I can't remember a mention of AI, and here it is a number of years later. And of course, this is moving so fast. Isn't that part of the problem too? That you don't want to put a code in effect that's almost ancient by the time it's put in place?
That's right. Because the technology has, within the past 2 years, AI has come front and center with ChatGPT, generative AI. So right now we're at a time where, we're in a new revolutionary, industrial revolutionary period where AI, machine learning, has become part of our daily lives, right? So if we don't make the correct regulations and changes in the laws now, we may be stuck with them for a long time, just like our internet laws, if you remember. Back in the 90s, we were supposed to regulate the internet, and we have the regulations, but things really haven't changed because there is a law. So being more precise and being more careful might be a good solution here. And again, both parties are not happy. So, one, the GOP side more on the business side, and the other more on the civil liberties side. So it may have been a good idea that there's been a stop put on the markup of the American Privacy Rights Act.
Well, yeah, a lot to think about. Of course, the draft of the act, at least at the end of May, would have prohibited covered entities and service providers from collecting, processing, retaining, or transferring covered data in a discriminatory manner. Well, that itself sounds like a great idea, and the trouble's in the details, what that means. And then you have these algorithms, covered algorithms, and every year a large data holder has to find somebody with $250 million or more in revenues would have to complete an annual impact assessment. So that's what you're talking about here. And they're saying, wait a minute, why would we have to do that? And then we've got to screen out of it things that discriminate. There's a lot to talk about here. So maybe the pause in the markup is going to mean no adoption of an act this year. We don't know. And it'll be up to the next Congress and whoever we elect as president.
That's
Yugo,
right.
any concluding thoughts on this update?
We'll continue to monitor, and we'll continue to see how the law or the bill develops. But Joe, I think you're absolutely right. It's very hard to tell, given that both sides have very, reasonable perspectives. It's not just a political stance, right? Each side are thinking about this issue very thoughtfully, and this is just a result of, I think, a thoughtful discussion. And it just takes time to come to a negotiated and a better solution. So it may take time, but I think we'll eventually get there.
And the lobbyists got a lot of work to do this year. You've got Microsoft basically supporting the act, and Meta saying, wait a minute, this is a problem. And, but that's how democracy works in America. Everybody gets a chance to protect their turf and have their say, and we'll find out someday what Congress does. And in the meantime, no comprehensive American data privacy law will be in place. Well, as always, I'll remind us all, dear listeners, ever more so, if you just listen to this one, protecting your personal data begins with you.